I am here with Austin Hepworth. He is actually the candidate for Attorney General who we are recommending that you vote for. A constitutionalist, knows the law, knows his stuff. I know there's been a lot of questions and confusion regarding Amendment C. Jason and I had done a video updating people on our recommendations on who to vote for, which, how to vote on the amendments, and that section on C got cut. And what originally had happened is we originally were for it, and then there were some concerns that I had, and I was very uncomfortable voting for the amendment once those, concerns were raised. So Austin actually helped me clarify some of those concerns. I'm feeling a lot better about it now. And as an attorney, he's got some great insight on this. So we are going to have a discussion with Austin today. We're going to go through the concerns, have a discussion, run through all of that so that you guys know what the concerns were and you have all of the information that you need to make the decision that you feel is best for you. So just to start out, originally I was for this bill, or I'm sorry, for this amendment, Amendment C. And what it does is basically what it's doing is it's taking the election for sheriff out from under state code and putting it under the state constitution. And I've had a lot of questions, well, why is that necessary? What are they doing? Why are they changing that? It is actually very, very important that the elections, I believe, go under the Constitution. And the reason why is, we have a governor who is wanting to appoint the state treasurer and wanting to appoint the state auditor and appoint positions that should be elected positions. So rather than us choosing them, he wants to choose who these people are. And though it isn't constitutional or legal for him to be running legislation, the reality is that he is giving legislation to buddies within the legislature that do his bidding and getting his legislation passed all of the time. And so in order to avoid, what happens is under state code, the legislature can amend or pass new laws and change what's going on with our election at any time, and we don't want that. So if we put the sheriff under the Constitution, that gives us as the voters, as the citizens, the permanent, it's really hard to undo once it's in the Constitution. It puts that power for the voters to choose who the sheriff is under that Constitution permanently, and then the legislators cannot amend that. They can't mess with that. Austin, would you say you would agree with that?
Yeah, that's a very good description to say that constitutionally, if they want to change it, we as the people have to approve it. Constitutional amendments in Utah require approval of the people. And so they can't change what's in the Constitution on their own. They'd have to run it by us, which is an important check and balance with elections.
Yes. So it is actually really important to put the sheriffs under the Constitution rather than state code. It gives the power to us, takes it away from the legislature. After we recorded that episode, and the reason that section got cut is because I had done some digging, and I know that I'm not the only one that has raised concerns. I know you've had other concerns brought to you by other people as well. But somebody had mentioned that the language, that they were changing the language over to an office. And when I did some digging into this, I came across code under Title 17 that talks about consolidation of offices, and where they had moved, from a person being elected to the office of county sheriff. It had moved it to the office of the sheriff county shall be an elected office. And I was really concerned about that language. And you can attest to this, Austin, I'm sure, but language is really important. You change one word and it can change the meaning of entire bills within the state legislature. So my concern was with this consolidation code. It states that if offices can be consolidated, so basically consolidate into one merged office, and then a new member is elected to kind of oversee all of those offices merged and redistribute those duties. Last year in 2023, there was updated legislation that became effective, stating that county legislative bodies would be able to consolidate offices. And with the corruption with Amelia Powers and a lot of these people we've talked about a lot on the show in Utah County, we know there's a lot of corruption in Utah County. That made me really nervous that we'd have county legislative bodies that might possibly, consolidate. Now that the language in this amendment was office instead of person, that we would be consolidating the sheriff's office, which potentially could eliminate the sheriff's position across the states. And so for that reason, I was, for a good last 48 hours, I've been frustrated, not knowing what to do about this amendment. And I reached out to Austin, and Austin actually clarified that for me. I feel like those concerns have been rectified. And if I understand correctly, and then I'll kind of let you explain this, Austin, the reality is, because we know that constitution power trumps statutory power, where this is actually creating an elected office versus that word person, now all of a sudden under the constitution it is a permanent office that is always elected by the voters. So if they tried to use statutory power to consolidate that office, it wouldn't work.
Correct. Yeah, that is correct as to that is my interpretation of it. Now with these things, to your point, the words matter, and these things, and when you look at it and really look at it deeply, there are some things missing or some things stated a little differently than in the past. And so it raises, I think, legitimate concerns to look at. And I think it's very wise for anyone to really dive deep into what's going on and to look at understanding these things. Because there are some places in our law, in our constitution and code, that talk about just the person. So for example, Attorney General, when the Constitution talks about that, it says the Attorney General. It doesn't say the Office of Attorney General. And so then we start to look into, well, are there differences in the law? Are they treated differently? And the answer is sometimes. Sometimes the person is different than the office, and sometimes they're basically the same. And so then it gets a little muddy to try and sort through exactly what's happening and why. Now, I will, though, just throw this out for anyone listening. When we talk about the law and we talk about how a judge could interpret it, even if the law says don't interpret it this way, a judge may still interpret it that way at the end. So all these things need to be taken with a grain of salt. I'm not here guaranteeing anything. So again, look at the competing possible interpretations. But I will share with you why I'm not concerned with the language, at least from my perspective. But part of that is admittedly in my projection of the future, which could be wrong. So, but as we look at this, I think the place to understand what's happening is to go back to this code you referenced. And if anyone wants to look it up, it is Title 17. Let's see, 17-16-3. Yeah, so 17-16-3, consolidation of offices. It became effective the May 3rd, 2023. And interestingly, I think this is actually what gave rise to this amendment even. So the two, I think, have some history together, because this amendment C that we're voting on was passed previously, and I mean previous to this year, and it's coming up for vote this year. But this is what happened is some counties aren't the same size as Salt Lake County, for example. And so for whatever reason, and this could be maybe it's a good thing, maybe it's a bad thing, maybe it's both, maybe there's some places it's good and some it's bad, but counties now have the power to put offices together. And so if you have your county surveyor and you have your assessor and recorder, a county could elect just to make those all the same. And that is a very interesting power to have. And to your point, Chelcie, this exists in state statute. So the state could change this at any time. And
Right.
the county can change this at any time too. So suddenly, if you look at all the websites for county sheriffs, everyone says the Office of County Sheriff. Well, I can't say everyone, at least the big ones I pulled up. I went through a number of them, and they all say this is the Office of the County Sheriff, the County Sheriff's Office. And, the sheriff is the head of our office type thing. And so as it stands right now in Utah code, the Utah legislature or any of the counties could take away the elected sheriff's office, which then leads to this amendment C to say, okay, we're sitting here, all of these sheriffs are elected currently, and so that is also gives people a little bit of concern to say, well, what's the concern here? Why are we passing this? And the Speaker of the House at the time, Brad Wilson, said, well, we want to make sure that the sheriff's protected in this. And so for whatever reason, they didn't put the protection in statute, which is probably a good thing in the sense that any statutory, quote, protection isn't really protection because it can just be revoked at any time by the legislature. And that's something important to know with amendments A and D. They were axed by the courts. They promised us certain protections with them, but they refused to put those in the Constitution itself. Their supposed protections were in statute, which can be overturned at any point. So watch for those games. But this is kind of the opposite, where they passed a statute and then said, okay, we will grant real protection by putting up an amendment. And so because the statute says they can change any county office, if you pass an amendment after that statute's in place, the amendment is always seen as changing something. So the courts will look at it as, okay, what did this change? And they will say, okay, based on the amendment C, every county has to have an office of county sheriff. So to them, to a court, if you start consolidating that office and get rid of county sheriff, you're no longer following the Constitution because it says it has to have that office.
Right.
And so at that point, the Constitution is trumping the statute. And to me, that language, the language in Amendment C is mirroring the language in this code to point out that we are carving out sheriffs as fully protected. Now, to your point, Chelcie, auditors aren't protected. These others aren't protected. There's still concerns there.
Right.
But at least the sheriff could be protected. And so now is the statute or is the amendment itself the model of, amazing drafting? No, probably not. There are some things missing. One of those things that's missing that some people have a concern about is that all county offices, and this is in basically the same area of code, but if you go to, let's see, 17-16-1, they talk about person filing a declaration of candidacy for a county office, and it says that they have to have certain qualifications. They have to reside within the county, be a registered voter there, that type of thing. And so some people are saying, well, this doesn't address the qualification in the Amendment C. And so that means that there's no qualifications anymore. Someone from Washington County can run in Box Elder County, and they don't even have to be a sheriff. And so people are essentially taking the absence of qualifications to say, well, that means a court will interpret it to mean there are no qualifications anymore. Now, I want to be clear, that's a possibility. If you talk to an attorney, they've all seen something crazy go on in court where you just kind of go, wait, what just happened?
Right.
But if we look at our current Utah courts, they just spanked the legislature hard on 2 amendments the legislature really wanted.
Yes.
And these courts have not been a fan of watching the games the legislature's playing with constitutional amendments.
Right.
So again, the Supreme Court steps in July and says, hey, Utahns have this constitutional right that's never been formally recognized before. And the legislature's livid about it. They go into special session in August, pass Amendment D, try and get it on the ballot, or get it on the ballot, I guess. But then the courts say, no, you're not being honest. You didn't publish it. You didn't do all these different things. You can't just change the requirements on your own. And they really spanked them hard on this.
Right.
And then Amendment A takes the same track essentially after D. And so I kind of look at it and go, we have to understand we're in this light where the courts right now have signaled under very strong precedent how they're looking at and interpreting things. And one of the things that brought Amendment D about was that the court said we have to give meaning to all terms of the Constitution. So because in Amendment D there was 2 different constitutional provisions, and one of them said that Utahns can alter or reform their government at any time, the court said if the legislature can just take that power back and just mess with things, then you effectively have no right to alter or reform your government when you take power away from them. Now,
Right.
I don't agree with everything the Supreme Court did in that case, but the principle for this is the court refused to leave a provision just hanging meaningless and just say, no, it doesn't mean anything. And that is something that's so consistent in Utah interpretation when they're looking at statutes or constitutions. They say, we're not just going to leave this hanging and meaningless. So that leaves us at the place of, okay, well, if there's an absence of something, it doesn't say what the requirements are to run for office. The question then that the judge would say and that the attorneys would have to answer is, did this provision, by not saying what the qualifications were, intend to remove all qualifications and override that portion of the statute too? It's clearly creating boundaries for a statute, looking at it. And even the legislative intent, if you listen to Brad Wilson talk about it, it's very clear this is to say people vote on the sheriff. From everything I can gather in legislative history, there was no discussion whatsoever of it modifying qualifications for the office itself.
Can I
And those,
insert? Can I
yep,
just insert something really quickly here? Because it's my understanding that just so the viewers are aware, when it comes to intent, my understanding is that's really important with upholding certain interpretations in court. And that's the whole point, you guys, is this how the language in this amendment is interpreted, right? If it would get rid of a sheriff, it would do these things that we're worried about. And so the intent is very important. And so because when these bills are discussed and the language for the amendment was discussed on recorded minutes within the Utah State Legislature, that recording can be used within the court, showing that this was the discussion that they were having. This was the clear intent, that this is what the amendment was supposed to do. So if they're trying to do something opposite of that, typically, if you have not corrupt judges in courts, they're going to uphold what the intent was supposed to be. If that's correct, I just wanted to throw that in there.
yep. And that's very correct. So intent becomes important when the statute's not, or the amendment, or the language isn't clear. So if the language doesn't say something and someone's claiming it means something because it didn't say something, then you can't look to the amendment itself to know whether it intended or meant to change qualifications. And so the judge is then, if they can't look at the face of the statute or the amendment, they will turn to intent. And they will go through, they'll look at what was presented to the people. They'll look at what the legislature discussed, but based on the recent precedent for Amendment D and Amendment A, the courts place incredibly high value on what was presented to the people. And if you look at what's presented to the people currently, it states, shall the Utah Constitution be amended to have the office of county sheriff be elected by voters? That is going to be probably the court's greatest sign of intent right here. And so if they say, oh, this was also taking away the any qualifications for county sheriff, then they have to deal with the Amendment A and Amendment D precedent, brand new precedent, in the
Right.
same election cycle.
Right.
And so to me, is there a chance that a court just disregards all that and just does their own thing? Technically, there's always a chance to things. Is it likely? From my perspective, no. I don't view it as likely at all that a judge just dismisses Amendment A and Amendment D, dismisses this whole political firestorm with all these things, and just says, yeah, we're going to pretend that even though you were never told as a voter that this would allow sheriffs outside your county to be elected, even though you were never told that they didn't have to be a sheriff, qualified as a police officer anymore, we're just going to stick it to you. That's something that I don't believe they would go through the whole rigmarole of Amendment C, because they can just do that right now. They
Right.
can do that by just consolidating the office,
Right.
and then they just get rid of it. And so why would we go through this whole thing,
That does
this
make
whole
sense.
exercise to take us back cunningly to this place we're at already? Now, maybe
Right.
they want to say, oh, we tried, and I don't know, maybe there's some great mastermind thing like that. But when I look at it all, when I look at the language I talk about having attorney spidey senses, where it's just kind of, you can
Yeah.
sense when something's off.
Yeah.
The language itself of the bill hasn't triggered that for me. I still, admittedly, I don't have complete peace about Amendment C, in the sense that I still, my mind wonders if there's something else going on. And so I think about it and I go, well, what do I do? Because there is just this little piece, this consolidation of office bill comes out, and I look at things like that and I go,
Yeah.
well, what are the plans? Someone has plans, right? We
Yeah.
don't know what somebody's plans are, and that's where this gets concerning, is to say, well, what's going on? But I look at it and say, well, I look at what would happen if the amendment passed, and let's say that it's amended constitutional right. What harm could that bring to us? One of the things is, let's say big money comes in and just starts into sheriff's races and does its thing. Then if we lose the ability for the county body to have some check and balance on the sheriff, we could have money influencing who the sheriff is. And that's something that we as a people would have to be willing to deal with. If it's an elected office, we're now responsible fully for what takes place there. And we don't traditionally put a lot of focus on the sheriff's race in counties as a
Which
people.
we should. We should.
We should.
They're
We
very
should,
important.
but we don't traditionally. And so, but then I go, well, if money's going to come in and do its thing, money will come in and do its thing whether or not there's Amendment C.
Right.
And I actually think it's easier for money to do its thing without an Amendment C than it
Right.
is with
Right.
it. And so again, each piece as I've looked at kind of the pros and cons to say, okay, let's even say we get back to the place where the court agrees with the interpretations that negate the whole amendment itself. We're back to where we are right now. But if a court doesn't agree, we have a protection. And so for me, as I look at it, I say, well, I'd rather have a fighting chance than virtually no
Yeah.
chance. And so to me, Amendment C gives us a fighting chance. Am I pretending it's perfect? No. Am I pretending that it spells everything out that it should? No. There are legitimate concerns people bring up, say, hey, it doesn't mention qualifications for office. Does that negate everything? And I look at it and I go, well, that would be interesting. I mean, you think about that as a judge, because again, the amendment language itself says, shall the Utah Constitution be amended to have the office of county sheriff be elected by voters? And that is a very specific thing to say. All that we're doing with Amendment C is we're making it elected by voters. We're not overruling qualifications for county offices. It's literally just to say this county office is elected by voters. And I think as an attorney, I'd have a very hard time convincing a judge that it means that anybody should be able to get into office as a county sheriff. You even just think about the ramifications of that. And one of the ways to defeat that, let's say that claim came up, we could just run Bozo the Clown for county sheriff and have that potential hanging there, and the judge looking at it going, yeah, no, I'm not going to do this. Because judges are realists also at some point, even though they do get wild and we don't trust them sometimes, they do come back down to, no, our sheriffs are pretty important people. They need to be trained. We have so much pressure in society on them to train them that they go, unless they were telling the voters this was the intent to open it up, I just see them going straight back to Amendment A, Amendment D that they spanked the legislature with and said, no, this wasn't part of the intent. This wasn't part of what was going on. This is purely to protect this office, to force it to be voted on.
Yeah, that precedent is really helpful there for sure.
Yeah, and we actually, again, prior to this, we didn't have precedent on these things. But
Right.
now we
So
have
maybe
two
it's a good
cases.
thing. Yeah.
Now we have two cases. So again, that just to me, just the way everything went, it's a very difficult obstacle to overcome to convince a judge otherwise, I think.
Right.
And so from a likely perspective, I view it as we have more protection than if we don't. And again, going back to your point about Cox once, he floated appointing the AG too. That was another one, auditor, treasurer, and AG.
Yep.
Those would be very damaging
Great.
to checks and balances, all of those, if they got appointed.
Yeah.
But why wouldn't someone want to appoint sheriffs? Because again, if you want to appoint the AG, why wouldn't you want to appoint sheriffs? Those things tend to go hand in hand. Power likes to centralize. And so you say, well, we need a
Right.
line of defense. Our county sheriff can be that if they choose to be.
Right.
Not all of them choose to be. And that's up to us to vote differently, I guess.
Right.
But this is something that we can really look at proactively to say, can we bake in some additional checks and balances and pursue this while it's here, while this opportunity is here to vote differently?
Yeah. And the sheriffs, sheriffs can elect or I'm sorry, elect, they can arrest judges, they can arrest the governor, they can arrest I mean, sheriffs are really our line of defense when it comes to really upholding those constitutional principles for us and our rights, just above it going to us having to defend ourselves in war, right? So the sheriffs are important. And if you remember, I think it was the state of Arizona, the governor had come out and said that she was temporarily banning all guns because of an emergency. I think it
Yeah.
was Arizona. And the sheriff came out and was like, yeah, you don't have constitutional authority to do that. And that's my call. And we're not enforcing that. So the sheriffs are a big deal. They're important. It is so important for us to elect them and not to give that over to the power of the legislature. And so it is very important to make sure that they do go under the Constitution and that power cannot be amended or altered anymore by the legislature. But like we're talking about, it's some of the language, the way that the amendment was worded in that language, it drew some concerns in how that language could be interpreted in the courts. And so hopefully that's been helpful to people to kind of work that issue out. But was there anything else you wanted to kind of elaborate on?
No, I think again with C, I have deep respect. If you're uncomfortable with it, I'd say listen to feelings inside, because none of us fully know everything. And again, we're trying to predict the future based on what we've seen in the past, and that's not always a great way to do it. But sometimes that's all we have to go off of besides whatever we feel inside. So don't dismiss if you have feelings of concern. Feel free to reach out. I'm happy to talk about things or go through things. And that's something that, again, I have deep respect for. If something seems off, reach out, look into it. There's still a few things off this election that I'm trying to resolve before I finally vote. I've got a few pieces left that I've got most of what I'm doing, but there's a few pieces that just don't feel right. And in my mind, they should, but they just don't quite feel right. So I'm still working through those. But this is the process, and we trust trust in the sense of a higher power to guide us, direct us, and then we do our best and we make decisions based on the best information we have. We move forward, and I strongly believe that there's some really good things coming. I strongly believe there'll be some really good things this election or after. I keep feeling really hopeful for where we're headed. So doesn't mean it's going to be roses necessarily, but there's so many people doing so many things, people researching, people looking into things. And so, yeah, raise questions, reach out, ask people, get opinions, but at the end of the day, listen to what feels right inside and move forward with that.
Perfect. And so just to kind of, for those that don't understand, legal mumbo jumbo, with as far as the qualifications for, because this wasn't my concern, this was actually a concern somebody else brought up, but all the issues you just said where they, are getting rid of, because all of the qualifications on, just like the president has to be a, US born member, and all these conditions on if you're allowed to be the sheriff, if you live within that county, whatever those qualifications are, because all of that is not showing up in the amendment. There are concerns that all of that's just going to be deleted and thrown out, and code will be nullified. And typically that's not how that works. The amendment would have to do a strike through, or give specific language saying that they were eliminating all of that. It's just that all of that still stays in code but can still be amended by the legislature. But it's the specific office of the county sheriff. We get to continue to elect that office that stays permanent under the Constitution. So if that's a fair description of that.
Yeah,
So
and that is, and again, it's to say that the Constitution, when it sets forth a constitutional office, it will often describe the requirements for that. So the requirements for president are actually set forth in the Constitution. They have to be 35 years old,
right.
natural born citizen, that type of thing. Um, and Congress can't place additional limitations on that. So some people say because we have this precedent where Congress can't place additional limitations on the office of president because it's spelled out in the Constitution, it's going to be applied the same to Utah. Now, again, I openly admit that's a possibility. I'm not saying it's not. But in light of everything, the judge has to ask, and this is why it goes to intent, what was this amending? Was it just amending, this little provision of statute that says they can consolidate offices? If so, all the other stuff in statute, the qualifications still stand if it didn't amend that.
Right.
And that's where the intent comes in. That's where this whole history side comes in. And that's why I say, based on everything going on right now, for a judge to reach that place to say all qualifications are thrown out the window, even though we never disclose that to Utah voters, I just say I don't view that as a likely outcome of this.
Okay.
But again, let's say that they go that route and throw out all qualifications. We as a people still get a vote. We don't have to vote for an unqualified person. And currently the legislature at any point and the county at any point could strip those as well. Which is,
Right.
I just go, well, okay, so we're already there, kind of. If it's just
Already
hanging
in.
there.
Yeah.
Yeah.
That's
Let's just
ready
go
in.
back to having the chance and the argument, at least to a court, to say, no, keep this right. And I
Right.
believe the most likely outcome of that court case, if it were to happen, would be the court reads it as only amending that the office has to exist and be voted on, but still allowing for qualifications by statute.
Perfect. So to clarify for everybody, my concerns that I had with consolidation, consolidating the sheriff's office, as you said, it's a valid concern. There's always that little chance that there's something weird going on with the language and how that's going to be interpreted. But according to you and from what you've seen, I know you said you're not 100% at peace with the amendment, but considering consolidation, you are comfortable with the language that's in there. You don't really see that being a problem.
Correct. From a legal perspective, I have very little concern for the language of it.
Okay.
It's
And
more
that
the big picture it's a part of. I don't fully understand. But the language of the amendment itself, I don't have legal concern over.
Okay, perfect. That was my only concern. So I appreciate you. Was there anything else you wanted to mention or go over? You feel like you've pretty much discussed everything you feel needs to be out there on this amendment?
Yeah, I think so. So
Okay,
appreciate you.
perfect. Yeah, I appreciate you. Thank you so much, Austin. It's great to have an actual attorney, and that's a big part of this is how language is interpreted in the courts, and so it's super helpful to have people like you speak to this. So I really appreciate the discussion. If people do want to reach out to you to, clarify or they have additional questions, how can they reach you? Email
Yeah.
or?
Yeah, so if you want to email me, that's generally a pretty good way to reach me. My email is ahepworth, AHEPWORTH, @believe.legal. And so again, you can go to my website, austinhepworth.com. You can submit a comment there if you want, or you can go to believe.legal, which is my law firm, and my email there is ahepworth@believe.legal. So feel free to email me, ask questions. And if I don't get back immediately, just know that I'm very tied up, but I will respond. And so I will try to do my best on those things.
I know you're busy. We appreciate you. Thank you so much. And just to the viewers, so you're aware. Again, my concern was the consolidation powers. The way that the language is, the way that Austin has clarified it for me, I am a lot more comfortable with that now. I think all of us there's still some things in the back of our minds with how some of this language might possibly be misinterpreted in the courts. However, I think, as you mentioned, with the precedent sent for the other amendments, we're feeling pretty comfortable that that's most likely not going to happen. So while there were valid concerns, and I'm glad that we've talked through them, it also is really important to get the sheriffs, under the amendment for the reasons that we spoke about. We don't want the legislatures being able to change to basically change us being able to choose our sheriff. So for those of you who are curious, who are, for my vote, I'm changing back to my original vote and voting yes on this. We just wanted to make sure that you guys had all of the information presented to you and walked through the concerns and all of the issues so that you could make the choice that was best for you. So appreciate you guys, and I will see you back in studio with Jason next week.